This is one of the most straightforward and easy constitutional law hypotheticals that you're going to have a look at. Questions exactly like this one appear both on the multi-state and on the essays. This is a standard constitutional law question presenting standard constitutional law issues. I characterize it as easy because most of us don't have to do a great deal of thinking to come up with the issues. They are basically spoon-fed to us. What makes this question challenging is everybody that's answering this question knows what's at issue. So we distinguish the good answers from the unsuccessful answers based on how thorough and how rational the analysis is. That's why being well organized and thorough is so important. And practicing questions like this one will give you a very clear idea about how the material is tested. Take a look at the call of the question. It reads, "How should the court rule on the issues raised by board's motion? Discuss." Well, there's nothing in that call of the question that identifies the subject matter at all. But as we read the fact pattern, we'll see that basically all of the issues are enumerated for us right in the fact pattern. In paragraph 1, we learn about the alternative education program, which is in place in a school district for unmarried, pregnant teenagers. And in paragraph 2, we meet Pam, who is the underlying plaintiff of the case. Pam is a 16-year-old who became pregnant and who was assigned to the alternate education program. At the end of paragraph 2, we find out exactly what her claims are. First, she is bringing a claim based on equal protection, and secondly, she's bringing a claim based on substantive due process. As we read closely, there are two obvious discriminations. There's a gender discrimination, since unmarried male teenagers, who are the second half of an unplanned pregnancy, don't have to go into this program. And secondly, there is an age discrimination, since it's only people under the age of 18 who have to go into this program. If you think about it a little more, there's another discrimination between married and unmarried teenagers. Now, we turn to paragraph 3, and we see facts that give rise to, and we also see, the board's motion. We find out that she, the plaintiff, ended up having a miscarriage. And the quick answer to that is the situation could reoccur. This is a little fact dynamic which is very commonly tested on the multi-state, and here we see it on a question that was originally an essay format question. So at the end of paragraph 3, we find the basis for the board's motion. First, they are claiming that the action is moot, and secondly, they're claiming that the complaint fails to state a claim under the Constitution. Well, this is a very easy question to outline. We know that our answer to the first section is going to deal with the basic threshold issues: standing, ripeness, and mootness. Clearly, the question is asking us about mootness, but we want to rehearse the other basic threshold issues as well, because that's necessary for a real review of the underlying substantive claims. So, with regard to those claims, we know that her first claim is going to be for equal protection, and we know that the second claim is going to be for substantive due process. And the reason we know that is because they tell us. This is not a question that requires us to inventory our own knowledge of the legal theories under constitutional law. We'll see other questions that do require that in the hypotheticals that we do together. But here, the examiners spoon-feed us the issues, and that means we've got to know our stuff in order to organize a thorough and rational answer. So turn the page and take a look at the outline of issues that I've presented. At the beginning, we discuss standing and ripeness. Clearly, this individual would have standing because she's been directly affected by the law. She was sent into the alternative education program. The case is ripe for review because no facts that are germane to resolving the legal issues are floating around unresolved. We know what the facts are, and we know what issues are presented. Nothing else has to happen for us to be able to resolve the case. However, the core of the board's motion is that the instant dispute is moot, and there really are 3 reasons that support the idea of mootness. The big idea is or the big reason is this plaintiff suffered a miscarriage. She's no longer pregnant. She's no longer subject to the program. But two other smaller facts are the academic year during which she was in the program has ended, and she's been returned to regular classes. So here we've got a plaintiff seeking to achieve constitutional redress for a situation that no longer exists. However, unfortunately for the defense, this is a situation that readily could be repeated by this plaintiff or by someone else similarly situated. The case is ripe for review. The mere fact that this plaintiff has suffered a miscarriage does not render the case moot, and therefore the first ground for the board's motion to dismiss is one that the board's going to lose, and the plaintiff wins. So now we get to the heart of the question, which is the constitutional theories. Once again, we're lucky because they gave those theories to us. But at the same time, that raises the bar in terms of our responsibility to provide a thorough answer. So probably the most common mistake that folks make in answering this question is to be too hasty and to consider this only a gender discrimination question. And it isn't. There's more to it than that. But I grant you, the core of the discrimination is a gender discrimination, and that means that the board is going to have to show that the discrimination is substantially related to an important government interest. Now here, I would grant that fairly competitive answers could be written that reach either conclusion. Certainly, females are more burdened by teenage pregnancy than males. We can disagree about how good that is. I think most of us would agree that's a bad thing. But still, that would make it rational for a regime to be set up that focused more on the mothers than the fathers. Personally, I think the correct answer to this part of the question is that the gender discrimination doesn't meet the standard of review, which, of course, is the intermediate standard of review. It's a close enough call that one could write a fairly competitive answer reaching either conclusion. But it seems to me that Pam's gender discrimination case is a winner under equal protection. Now, the other major discrimination is an age discrimination, and arguably a discrimination between married and non-married individuals. For both of these discriminations, the rational basis test would likely apply. And consequently, I say that the board's motion to dismiss based on Pam's failure to state a constitutional claim is going to be denied, certainly with regard to the equal protection claim involving gender. But now we turn to her substantive due process claim. Here, she's got an even stronger hand than she does with regard to her equal protection claim. And the reason is this statute is targeting a fundamental right, which is the right of privacy, the right of procreation. And as a result of that, this is going to trigger strict scrutiny. So the board is going to have to show a compelling state interest and no less restrictive means, and they're not going to be able to show that. Now, one would wonder, interestingly, suppose this program did not discriminate between the sexes, and suppose further that it didn't have any other discriminations that would be arguably a constitutional violation. Under those circumstances, would both male and female students have a substantive due process claim based on this program? And the answer is they might very well have such a claim. Fortunately, that's not really what's at issue here. Now, on a multi-state question, I think you'd find that these issues are pretty easy because one of the four answers would be notably more correct than the others. But on an essay, constitutional law can be a lot more subtle and a lot more difficult than it is on the multi-state. This question, I think, is a fairly easy question because you don't have to figure out what the theories are. But once we get into the question, we see that, in fact, it really is quite a subtle question, and therefore maybe not as easy a question as it appeared when we first looked into it.